Going through a divorce is tough enough, right? Don't let car title changes make it even harder. Welcome to the Explainer. Today, we're mapping out the exact steps to remove a name from a car title in Florida after a divorce, ensuring a totally stress-free transition for you. If you're looking for clear, direct guidance to finally separate your assets, well, you're in exactly the right place. Let's dive in. But first, consider this real-world horror story pulled straight from a legal advice subreddit. Someone posted, "Ex-wife did not update car title, got my license suspended." Yikes, right? It perfectly illustrates the immediate, severe stakes of ignoring your vehicle paperwork. If you think the legal ties are just automatically cut the second that divorce decree is signed, you might literally be driving straight into a financial and administrative disaster.
To avoid that nightmare, here is our roadmap for today. We're going to cover 1. The post-divorce title trap. 2. Essential documents you need. 3. The step-by-step transfer process. 4. Handling existing vehicle liens. 5. Dealing with uncooperative exes. And finally, 6. Finalizing plates and insurance.
All right, let's jump straight into Section 1, the post-divorce title trap.
So, leaving a former spouse's name on a shared vehicle title isn't just some minor administrative oversight. It's actually a massive legal and financial danger. Here's why. Your property rights automatically shift beneath your feet. In Florida, while you're married, a jointly titled car is often held as a tenancy by the entirety. Now, this is great because it actually shields the car from the individual creditors of either spouse. But the very moment that final judgment of dissolution of marriage is entered, poof, that protection evaporates. The ownership automatically severs into what's called a tenancy in common. And this means an ex's individual debts could suddenly target your shared vehicle. A judgment creditor could legally levy upon your ex's 50% interest in the car you're actively driving.
And honestly, it gets even riskier. Florida operates under what's known as the dangerous instrumentality doctrine. Basically, this is a common law rule imposing strict vicarious liability on a registered vehicle owner for damages caused by anyone driving it with their consent. So what's the bottom line here? If both your names remain on the title and your ex gets into an accident, the injured party can pursue a judgment against both of you. You share massive civil liability. Getting that name off the title is absolutely crucial.
Okay, moving on to Section 2, essential documents you need. So, how do we actually fix this and protect your assets? This is where we shift from the scary legal stakes to, actionable preparation. Before you even think about heading to the local tax collector's office, you have got to organize your paperwork. Much of this you can actually find via the Florida DHS-MB online portal. Here's your exact checklist. You're going to need a certified copy of your divorce decree, a valid photo ID like a Florida driver's license or U.S. passport, the current vehicle title, a completed Form HSMV 8240, proof of Florida insurance, and, if the car was financed, a lien satisfaction document. Having these documents perfectly organized is absolutely the secret to a fast, smooth process.
Now, the core piece of paperwork you'll be dealing with is Form HSMV 8240, the application for certificate of title. Don't let all that dense text intimidate you. However, you really need to know that Florida enforces a strict no-error policy on this form. I mean it. There are 0 exceptions. If you make a mistake, you can't cross it out, you can't write over it, and definitely don't use whiteout. Any manual corrections will cause the state to automatically void the application, and you'll just have to start all over again. So take your time and fill it out cleanly.
Next up is Section 3, the step-by-step transfer process.
All right, so your documents are pristine and ready to go. Let's walk through the actual mechanics. The very first thing you need to do is look at your current title and check the conjunctions joining your names. In Florida, conjunctions dictate everything. If your names are joined by the word "and," the state requires signatures from both owners to legally transfer the title. But if the names are joined by "or," well, it requires a signature from only one owner. Now, most DMV offices and dealerships default to "or," but you need to verify this immediately so you know exactly whose signatures you're going to need to collect.
Next, when you're filling out that Form 8240, pay incredibly close attention to Section 9 regarding sales tax. To claim your tax exemption for this post-divorce transfer, you absolutely must check the box for divorce decree. Your certified divorce decree is the official proof that makes this exempt. Now, a really critical warning here. Do not check the gift box if you're making informal payments to your ex or assuming an outstanding vehicle loan. Classifying a transfer as a gift while money or debt is exchanging hands is considered tax fraud. Just stick to the divorce decree classification.
Let's talk about the costs. A standard used vehicle title transfer is $75.75. If you're recording a new lien, add $2. If you want the physical title printed right there in the office, a fast title fee is an extra $10. But pay really close attention to the late penalty. Florida gives you a strict 30-day window to complete the transfer. If you exceed 30 days, you get hit with an automatic $20 late penalty. So prompt action literally saves you money.
Moving along to Section 4, handling existing vehicle liens.
Financed vehicles are practically guaranteed to be one of the biggest roadblocks you face. The crucial point to understand here is that transferring a title doesn't just magically erase the underlying debt. The Florida Department of Highway Safety and Motor Vehicles simply cannot issue a clean, sole title to you as long as an active lien is on the record. It has to be legally satisfied and released by your lender. This usually means you can't just swap names. You actually have to work directly with your bank to formally refinance the vehicle into one name, which allows them to release the old joint lien and record a new one.
Let's dive into Section 5, dealing with uncooperative exes. Now, what happens when things aren't exactly amicable? We really have to acknowledge this incredibly common and, let's face it, deeply frustrating scenario. What if your ex flat out refuses to sign the vehicle title? If you have an and title, you absolutely need their signature. If they ghost you or actively block the process out of spite, are you just stuck with shared liability forever?
Thankfully, no way. Florida has a very specific legal workaround for this exact situation. It's called the Procedure TL-17 Court Order Override. Here is exactly how you bypass their signature entirely. Step 1. Obtain a certified copy of your final dissolution judgment that explicitly awards the vehicle to you. Step 2. Compile what's known as a TL-17 packet. This includes the decree, the current title, your proof of insurance, and your completed Form 82040. Step 3. Submit this entire packet to the tax collector. The state will actually use your court-ordered divorce decree to force the transfer, completely overriding the need for your ex's signature.
And finally, Section 6, finalizing plates and insurance.
Please do not skip these final administrative tasks, or you could trigger those severe penalties we discussed at the very beginning. Here is a fact that trips up so many people. In the state of Florida, a license plate is assigned to the individual owner, not the vehicle itself. If you're the spouse giving up the car, you must physically unbolt and remove your license plate before you hand over the keys. If you let them drive away with your plate, you're just asking for trouble.
And here's exactly how you protect your driver's license. First, remove that physical plate. Second, file Form HSMV 8250. That's the notice of sale within 30 days to formally update the state database and terminate your civil liability. Third, surrender that physical plate to the tax collector or submit a cancellation affidavit. And critically, only cancel your auto insurance after the plate is officially surrendered. If you cancel your insurance while the state still thinks you possess an active plate, they will automatically trigger a driver's license suspension. That is exactly what happened to the person in our Reddit story earlier.
So what's the ultimate takeaway from this explainer? Act promptly. Don't let your past marriage dictate your future financial and legal liability. Remember that 30-day deadline we talked about? Gather your documents, check your title conjunctions, and make that trip to the tax collector's office to secure your independence.
As always, a quick disclaimer for you. This explainer is for informational purposes only and doesn't constitute legal advice. Every divorce and financial situation is unique. Please consult a legal professional or reach out directly to the Florida Department of Highway Safety and Motor Vehicles for specific assistance regarding your title transfer.
I'll leave you with this final thought to ponder. Are your assets truly separated, or is an old vehicle title sitting in a drawer somewhere secretly linking you to your ex's liabilities? Don't wait to find out the hard way. Go check your paperwork today. Thanks so much for learning with me, and I'll see you on the next explainer.